Hello and welcome. My name's Sophie Watson. I'd like to welcome you to the social science series on research concerning COVID. In our faculty, we don't have any law, so I thought it would be interesting to talk to a lawyer about issues of social justice in this current time. And I've asked Roger Smith, who kindly agreed to come on, and very pleased with that, Roger. Nice to see you. He's a very busy person. Doing all sorts of interesting things, including running a website on access to justice in the context of technology. And he rides his bike all over London, so I've stopped him doing that today. And very pleased to have him here with us. He was one of the people who set up the Camden Law Centre back in the 70s, which was a terrific initiative, I think. And so welcome, Roger. I'd like to start by asking you, what do you think the impacts of COVID are on the general scene at the moment in relation to justice?
Well, I think we can take it in two parts. The first part is the immediate impact of COVID. So if we take a number of parts of the justice system, you could say impact one is that if you go down to your local solicitor's office because you want to buy a house or defend a case of some kind, it's probably shut. And you won't be able to see the people face to face in the way that you would have done. You'll probably do a phone call and work a way around that. Slightly more serious, if you're arrested in a police station, you would normally get a lawyer, a duty solicitor to advise you, and that should still happen, but it might be more problematic. The most serious cases are on hold. Jury trials are on hold for the most part at the moment, and there's a major move to sweep most of the smaller cases onto non-physical hearings, digital hearings on the net. So that's impact one. Impact two is, really there will be a change in the type of cases that people need advice on. The Citizens Advice Service has a very interesting way of tracking questions on its website, and it can trace the type of cases that people are asking questions about. It's probably the best index we have of what the problems are. And as you would expect, the problems were, once COVID hit, about universal credit, debt, housing, employment. And so people are having those questions and they're trying to find some way of getting them resolved, getting advice on them. So those are and of course then you've got the impact in the larger international world, which is rather remote from individual people and probably in a sense doesn't matter to them so much. But there's clearly a bit of a slowdown in terms of commercial activity globally with large commercial companies. There will be a lot of advice going around about insolvency and redundancies and the negative aspects of business. There'll be very little going on in terms of positive attempts to put together deals and so on.
No, that's really interesting. Actually, what do you think the commercial aspects are? Because they don't talk about that very much when they talk about the economy.
No, I mean, law is a major income. Law and lawyers play a variety of different roles. One is they facilitate business and they're ancillary to business. And lawyers in the city thrive when business thrives. And we earn a lot. I mean, I can't remember the exact figure, but I think it's probably £24–25 billion from facilitating international deals, big commercial deals of one kind or another. And I guess those are all on hold. There's an immediate impact of that, actually, in terms of, for young people coming into the profession, because historically the large city firms have provided disproportionately more training places than smaller firms. That's where I got my training, one of the big commercial firms. And they are now, some of them, restricting the numbers that they're taking in. And so it may be harder for young people to come into the profession, which would be an immediate effect, or an effect which will take effect in September, sort of thing.
That's really interesting. Well, I know, Roger, that you've worked a lot on the question of digital technology and justice more broadly, which of course is something that we're thinking about in relation to COVID, but it's got a much earlier history. I know you've been working on this for a few years. So Let's talk a little bit more about the whole impact of digital technology on justice and the system of justice.
Well, let's have this conversation on the basis that we're interested in people who, how should we define them, who historically would have been entitled to legal aid. So you're talking about people on basic benefits and very low incomes, if we just talk about them. And they would have been the clients, when you and I met at Camden Law Centre, the sort of people who came in through the door there. And historically, those people, like most clients, have seen if they've been able to get advice, and that's been a problem, but they've got it face to face. Law centres and small firms serving that kind of clientele they haven't had much infrastructure in terms of digital. They have done most of their work face to face, and they've done most of it pen on paper. Now, over the last decade or so, those firms and organisations have begun to digitalise. So prior to COVID, there was a move over, should we say, from about 2010, over the last decade, of law centres and Citizens Advice Service, other agencies, small firms, getting case management. Well, first of all, I suppose it was word processing, and then moving to digital file keeping and case management operations, which allow them to store their information on clients and so on the cloud. And that was the process that was going through. At the top end, at the city end, that was pretty advanced. At the bottom end, where money is less available, it was a kind of slow, halting, irregular process. But if you looked at what has happened prior to COVID, that was probably the major impact of technology, with one or two explorations around the world of how technology might be used actually to improve services. Most of them, frankly, not happening in the UK, more of them happening in the US. And that would be things like explorations with, could you use the net to set up standard letters and forms that people could complete themselves? So you could help people to appeal a benefit claim by providing a pro forma, with varying degrees of sophistication, pro formas that they could fill in, which would range from a simple sort of PDF fill in the gaps to actually taking people through the process. And actually there's two good examples here of letters which were about claims in relation to personal independence payments, which are paid to people with a disability in addition to their basic means-tested benefit. And they took people through what the qualifications were. And these are benefits which are, on the one hand, very discretionary. On the other hand, you have a rather draconian medical assessment. And you have to get the messy tangle of your experience of disability into a form that reflects the official requirements. So people often forget that, find it difficult to deal with. People have some form of handicap which is worse in the morning and worse at night. It is a variable condition through the day. You want to pull that out and make the most of it in terms of a claim. And often people don't do that. And that's why they get, they're asked, can you walk to the shops? Well, yes, I can some days, but not others. And so helping people draw out the claims. The beginning of that sort of process of helping people do their things. The beginning, not so much here, but around the world, of taking up an old idea, which goes back to the 70s, in my experience, of legal making a positive of that, and saying,
wondering about.
Of saying, we want to empower people to solve their own problems. So a bit of recurrence of a literature and thinking, which I can remember from back in the day in law centres. Going with that, particularly in third world contexts, a lot of people taking up that kind of language if they're dealing with countries in Africa and so on, where there isn't the money for the kind of legal resources that we have here. So to recap, what was happening before COVID? Migration towards digital support for working practices, some, I would say, peripheral and uneven experiment with delivering services in a digital way.
Right.
And some experiment too with moving beyond the use of the computer screen as a sort of vertical book. The most advice sites, you want to look up what the conditions are for a divorce. Most websites will look like a book. Gutenberg would recognize most websites giving advice. And around the world, there is a little bit of an experiment with moving away from that and using the interactive capacity of the web. So instead of saying there are 5 conditions for getting a divorce, beginning with you, what is your situation? Do you have children? How long? And then beginning with you and then giving you advice which is tailored to you, which is often called a guided pathway. And that's sort of halfway to, that's how most chatbots work. And beyond that, there's a dream that people have that maybe you could move to artificial intelligence during that process. But a little bit of experiment of that. And linked to that, there was one really interesting experiment in the Netherlands with a website which combined that approach with actually helping people through a court case, a family law case, where not only did it give you information in that sort of guided way, it also, there was a question at the beginning of it, what's your negotiation style? Do you, or how do you respond to conflict? Are you reasonable, or are you unreasonable? And when I filled it in as a dummy, I said I was terribly reasonable, and my partner Sue was completely unreasonable. I was still recommended for mediation. So some attempt to be right at the beginning interactive, and some attempt too to say to frame the question. So actually, if you go through a divorce, you've got about 6 major questions. You talk about the children. You got what? Question number 1, access. Question number 2, custody and finance. There are 1 or 2 extra bits to it, but essentially that's it. So saying, well, what are your children, and what do you want, and feeding back to you. Well, many people in your sort of situation, now you've told us the details, would expect to get this amount of access and so on. So interestingly, an attempt to recreate what the lawyer would tell you. You go to a lawyer and you say, the chips are down, what am I going to get? So access 3 days, my kind of lawyer says, access 3 days a week, stuff it. You're going to have to, it's alternate weekends. You're not going to get away from that. And the max you can get out of him with his kind of income is, £500 a week or whatever. So an attempt to put that. So going back to the position before COVID, gentle explorations. The Dutch thing, in fact, didn't thrive. It had the funding pulled on it for complex reasons. The model of the guided pathway is still being sort of explored and taken up. Self-assembly documentation is being explored, but the main emphasis was on the main effect of technology has been to improve the working spine of organisation. So you've seen it in the back office until COVID, and you didn't see it much out there actually affecting the delivery of services.
Well, that's fascinating. Well, what about court? Because as I understand it, people are, obviously you can't go to court anymore. I have a friend who's family lawyer, I think, and she said she's doing these courts virtually. What are the impacts of that? I mean, that sounds to me quite complicated and complex.
Well, it's highly complex, and it's a little story of its own, because the government decided, as part of the cuts, the austerity cuts, that for lawyers came through with legislation in 2012, which was in an act that had the initials LASPO, so they're often called the LASPO cuts. That actually cut legal aid for general advice, for family work, except in some circumstances, and reduced remuneration. So quite a major cut in the service that people got. they were designed to save about a quarter of the budget, which was about 400 million. So that was one part of the Ministry of Justice delivery on austerity. Another part was to come from the courts, where there was sort of similar type proportion of cuts. And the wheeze that somebody thought up for that was, well, we'll deliver our cuts to the courts through flogging off courts buildings and justifying that by going digital. So I just think it's the wrong way around, but we are in the process of selling off courts on the assumption that there will be digital services to replace them. We're doing it, you might say, get the digital services up and then sell off the courts if you don't need them. But it's been done that way to raise some of the money for it. And that was a process which was going through before COVID struck and was very controversial, and there's a lot of rows about the courts that have been cut. The digitalization program is pretty extensive. It will, by 2023, extend through the courts and into tribunals. So people, I don't know if you saw the film I, Daniel Blake, but at the end of I, Daniel Blake, he ends up before a physical tribunal. Yeah. He won't. If you make Daniel Blake in 5 years' time, he'll just have a digital hearing. And whether he'll get the same result.
Well, that's interesting, isn't it? I mean, well, I think that's actually an interesting question, because it raises the kind of whole issue about, court behaviour, like how people behave when they're faced with the judge or faced with the jury and so on and so forth. Because hasn't law always been quite sort of performative? Like the lawyers have been, the classic kind of courtroom sort of drama and so on. I mean, what's it going to mean for all that? The way in which people behave and how juries judge?
That's the really big question, and you can phrase that in a number of ways. One way of phrasing it as a sort of policy question is, well, what types of hearing might safely be held by video? I mean, if you and I are lawyers and we're just, the only issue between us is this case going to be heard on the 5th of August or the 10th of September? The judge is not going to lose that much by us going to and fro on that on the screen. So procedural hearings are the easiest example, I think, of something. What happened with this program is, and there are various bits where it's really desirable. I mean, it's mad in a world which is digital to have to do what I spent a large part of my training doing, which is go physically to the Royal Courts of Justice, stand outside a room and get an official to rubber stamp a writ or whatever. So there's clearly a need to digitalize things, and people are using email, and you get secure email much better than writing and so on. So the whole part of this thing is uncontroversial. And indeed, if you look at what's been done in the Supreme Court, the very top court, it's all online. It's having online hearings at the moment. You can, that's a real advance. So, and anybody in this country can dial in if the court's sitting and see it. So there are advantages here. And what was happening was a program of reform was going through, and we were just beginning to see what could be done. COVID has accelerated all that, because some types of cases have had to be heard. Some cases have been stacked, and some cases have been brought forward. And questions, and the sorts of questions you're raising, which is, does a video change an oral hearing, are now having to be confronted. And you can take a variety of positions on that. What we actually need is some data and some experience and some research.
I mean, what do you think?
And
what do you imagine might be the effect?
Well, I think in a way it's to play for. I have been arguing that we should accept the move to digital. I was on the very first committee, before there was an official committee, that argued, it was chaired by a guy called Richard Susskind, who was the big guru of this area. I was on his committee, and I believe, as a matter of principle, there's nothing wrong, indeed it's desirable to go digital. I'm entirely digital, and there's every reason why the court should. And I just remember the courts and the court offices of my youth, where people were piles and piles of paper, with the red tape around them and all the rest of it. And we've got to move, and it's got to be better than that. Yeah. And it should be cheaper, and that should mean that it's cheaper for poor people. So it's desirable in principle. But I think where we have to go now is, well, what's suitable for digital hearing and what isn't. And the different things begin to interact because of the cuts to legal aid, there are more litigants in person in the courts. I think litigants in person raise questions about the technology. They are the poorest people, the ones I'm concerned about, have the lowest incomes. Therefore, they're likely not to have a relatively state-of-the-art Mac that I'm talking to you with. They won't have an iPad and my range of digital Apple products. They might have a smartphone, but they might not have any money on it. So if they use, so there'll be a debt to popping into Starbucks or their local library, or more flyer than will, to pick up the free Wi-Fi. But that's, there's an argument about the accessibility of digital and the impact of a digital divide, which will be around in terms of general policy. I mean, the policy in relation to benefits is to go digital by default, and indeed government services to go digital by default. And the big open question is, well, what is the percentage of the population that can't handle that? And we don't know that, and we don't know the issue of the courts. The problem there's a particular problem for courts, it seems to me, in that, one, I mean, this is my iPhone. If we're trying to handle a court case through this iPhone, where there are also documents, that's a nightmare. It's not possible, really, and particularly not if I'm here on my own. So there are all sorts of problems about the command of the technicalities, the linguistic, and then there's secondly the issue of, is the medium the message in the medium? I mean, and do you come to different decisions about people's credibility, for example, if you can see them on video rather than if you see them face to face? And there is evidence that you do, that it affects how you see people. And there's evidence too that people who are dialing into a court don't feel that they're part of a formal state process. It's much more informal, which wouldn't necessarily be a bad thing, but it sort of begins to fray the edges of the process. Yeah. So there are issues about the technology as it's used and the technology as it affects the I'm trying to avoid saying the majesty of the court, but the symbolism,
the weight or something. Yeah.
Yes. Yeah. The gravity of court. Yeah.
I understand that. I think that's really fascinating. I mean, could you possibly have a murder trial on digitally? I'm sure you couldn't really, could you?
Well, I wouldn't want a murder trial. I mean, I think that the exercise that I've got into, which I'm quite interested in, is taking a position which is, okay, we'll go for, if you want to use the word digital by default, you can use that. We'll use digital where we can. But what are the types of case which, at least at the moment, are not suitable for digital? I think there's a big question about crypto. I think there is a big question too about cases where at issue is a judgment or a decision of the state. So if the state wants to take away my children, I don't think that, I'm not very happy with that happening on a video hearing. I think you have to be in the court for that. I would argue. And I think if it's a very complicated case, I think it's difficult. And if there's a conflict of fact, I say this, you say that, I think that, and then the fifth one, which where there will be trouble with the government, I think if you're dealing with litigants in person, then they should have a right to say, I want a physical hearing.
Right.
So individual, because if it's just two lawyers, I mean, you can go online, as I said, and watch the Supreme Court or the Court of Appeal, and they're dealing with relatively arcane points of, well, not necessarily arcane, but they're dealing with points of law. You know, does this section mean this? Does the common law mean that? And you can deal with that relatively satisfactorily by video. But if we're just, down in the nitty gritty of, did you hold him down while your friend kicked him, or did you not? Or, where we the car crash.
Yeah.
Or conduct in relation to two partners in a relationship. Those are the kind of questions which I think one probably wants to have a physical hearing. And in policy terms, it's really, I think the issue will precipitate out, particularly around, do individuals have a right to demand a physical hearing of their social security claim, / immigration asylum / employment. There is a danger that the most expensive cases will be dealt with impeccably by digital means, and the ones at the bottom of the pile will be just tumbled in and swept under the carpet.
Yeah, that's fascinating. I was just thinking, as a side note, what do you think is going to happen to all those courtrooms? When are they going to turn into sort of Wetherspoon pubs or something? Or we're not going to have Wetherspoon?
Travel lodges, the grottier accommodation will turn into travel lodges, and the upmarket courts that represented the splendour of the 19th century will be plush apartments for rich people. So wait for the day when the Old Bailey is transformed into millionaire apartments on the fringe of the city, and as Billingsgate itself, the remnant of an Old Bailey is stuck somewhere on the periphery. That's the danger. Some of them are architecturally wonderful, and they represent a civic pride, and they will be valued as bijou residences.
Yeah.
The rest, if people are staying in hotels, they'll become hotels.
I find that quite sad. It's another thing, actually, that I'm thinking in relation to this, is that it will no longer be a space where people can protest or come and see people being tried. I mean, that interaction between the public and the legal system. I mean, for example, when there's a case that some group feels strongly about and they go and kind of wave banners around outside or whatever, I mean, that will all go, won't it? There'll be much more, almost one might say, privatization of the public law. Is that a reasonable claim to make?
Well, it's I think it's a number of things. Effectively, it's a reduction of the public space.
Yeah.
And one thing will be where you go to demonstrate. It's more than that. I mean, I was a sad child. I used to go to courts and watch them. And that will be, I used to go to the High Court, the Royal Courts of Justice, and the Old Bailey. Well, that probably still exists, but your local magistrates' court won't be there, just as your police station won't be there. So there will be, these were visible, they were built as the impressive buildings they are, as a demonstration of the power of the public. And they'll go, and you won't be able to demonstrate in them, you won't be seen near them. And the danger is that a court hearing or a tribunal hearing will come down to you're either going to the Old Bailey or 3 or 4 court venues around the country, or you're doing it on the screen.
Yeah,
and I think that's a reduction of the public role and the public space, and as you say, public place to demonstrate.
Yeah, I agree with you about that, and that's something that's quite worrying, I would say. I mean, in all sorts of parts of of the public sphere that are getting reduced, that concerns me. But that's a direction that we can't really, in a sense, stop. It's happening with so many public services, isn't it? Well, we can stop it.
Well, we're at the point of making those decisions now. Yes, and I think the issue is what's the impact on the social fabric?
Yeah.
If you look at the states at the moment, there's a breakdown in terms of race, people feeling excluded.
Yeah.
Well, these were these public services, libraries, local authorities, courts, police stations, they were the visible presence in your community of the public. And we're getting rid of them. And I think I agree with you, there are some downsides to that sociologists can get stuck into.
That might be a very good place for us to end, Roger. Leave us with some questions that are unanswered is always a good thing for us.
Yeah, so all research studies end up saying more research is required.
Exactly. That's what keeps us at work.
I know that. That's right. How's your book on water going? I nearly ended with a reference to water.
I'd like to end this interview publicly. We can always talk privately afterwards. And thank Roger Smith for coming to us today to talk about the justice system and technology. And it's been absolutely fascinating, Roger. So thank you for your time.
Thank you.